Welcome to the Jenna Ellis Show, sponsored by Legacy Precious Metals. There has never been a better time to invest in precious metals. Visit legacypminvestments.com. That's legacypminvestments.com. Good evening and welcome to Jenna Ellis Tonight. The Supreme Court earlier today heard oral arguments in a case involving a statute that has been used to charge at least one, but multiple January 6th defendants for obstructing an official proceeding. So joining me now to discuss is Will Chamberlain, who is senior counsel at the Article 3 Project. And Will, I know both you and I listened to that oral argument. To me, it was absolutely ridiculous what the Solicitor General was arguing in terms of why the government used this statute, which carries a maximum of 20 years in prison for a violation against January 6 defendants, but not against other similarly situated protesters or rioters, whatever you'd like to call them, that obstructed other official proceedings, like, for example, Justice Kavanaugh's own confirmation hearings. I was surprised he didn't jump in and correct Justice Sotomayor and the Solicitor General when they're like, oh, nothing like this has ever happened in the history of the United States. That's just false.
Yeah, I mean, that's the fundamental weakness of the Solicitor General's case. I mean, the expansiveness. If her interpretation is correct, then anybody who interrupts a hearing in order to try and stop the hearing or delay it or do anything has the corrupt intent necessary to be found guilty of this crime. And so you're going to start throwing out 20-year, a charge with a max sentence of 20 years, but in reality, 3.5 to 4 year sentences to just any of these protesters. And we all know that the people who protested Kavanaugh's confirmation had a $50 fine.
Right. And so, I mean, we can see that whether it's selective prosecution or whether it's prosecutorial discretion only goes in one way, and that is generally for viewpoint discrimination, because they didn't approve of the rioters for the basis of why they went into the Capitol on January 6th, but apparently did approve of the rioters that came in to disrupt the Kavanaugh confirmation hearings and other protests, like the pro-Palestinian protests that they often get off with a fine. So really, though, what this comes down to is statutory construction. And so we heard a lot about, the nouns, the verbs, the sentence structure, the congressional intent. What is this case ultimately about in terms of the statute itself? And why is it so important to have a narrow construction for original intent of what Congress actually authorized rather than this overbroad use?
So it's really a question of how you deal with statutory context. We're not talking about legislative history here, but we're talking about how do you interpret a statute in light of its neighboring statutes and what Congress was clearly trying to do based on when looking at the law. And if you look at the statute in isolation, you might say, oh, well, it covers any kind of obstructive conduct that affects any official proceeding. The certification of votes on January 6th was an official proceeding, ergo, everybody's guilty of it. But if you look at the broader statute, it's in the context of obstruction of justice generally and evidence impairment. So it's a catch-all to deal with evidence impairment, things like destroying evidence, tampering with witnesses, otherwise trying to defeat the efforts of a judicial proceeding. And so the interpretation that the government has chosen basically, yoinks this catch-all out of the statute entirely and allows it to be this very broad, vague crime that can capture any amount of conduct. And just an example of how troublesome this provision is, it's the provision that was used by Andrew Weissman to try and go after Donald Trump when he, as it was his right, tried to tell James Comey to stop investigating the Russia issue. And I mean, when I say that it was his right, it's because he was the president and he's in charge of taking care that the laws are faithfully executed. So if he determines that an investigation shouldn't occur, that investigation should not occur.
And so, Will, when we talk about statutory construction, it is so important to read this in the broader context. I mean, this is basically proof texting, and this is what the Democrats and the leftists love to do and to depart from the original intent and the plain language, and just to lift words and phrases out of statutes and then bend them and construe them to apply however they want. And just from a fundamental fairness standpoint, the law has always recognized the proposition that fundamental fairness requires adequate notice and fair notice. And so if this statute could have been applied in this instance, and the Supreme Court doesn't side with the petitioner in this case, the January 6th defendant, then what does this mean in a broader context about the notice requirement? Because then basically the Department of Justice or any prosecutor could try to lift a word or phrase and construe it to say, oh, you're guilty of something that you were never put on notice was criminal activity according to that specific provision.
Right. I mean, that's the theory underlying the rule of lenity, which says that criminal statutes should be interpreted when ambiguous in favor of criminal defendants, because that's only fair. They're the person whose liberty is on the line, and they're the person who proper notice was needed to make incarcerating them and depriving them of their liberty a reasonable thing for the state to do. But that's not how the DOJ looks at things. They decided that, oh, we're going to take this extraordinary interpretation of the statute because it will let us impose really strict draconian sentences on these people. And they never considered, what does the statute mean? What is the Supreme Court going to think? And moreover, have we been remotely consistent in how we're doing this? And I think that, that's one of the reasons so many of us look at the modern left and think, this is just they're focused on power. They're not focused on procedural or fundamental fairness at all. And unless you can make them feel the pain of their own rules, they will be as draconian as they possibly can with you.
Yeah, and I think we're seeing that because the left is trying to prosecute their political opponents. Obviously, Donald Trump being one of them, but also, a lot of conservatives, a lot of Christians, and we see that not just related to the post-election aftermath and January 6th, but also, some of the pro-choice protesters and some of these things under the FACE Act. I mean, we could go on and on with different examples. But getting back to this particular oral argument in just about the last minute and a half that we have with you here. I was really surprised that the Solicitor General, when asked why they haven't applied this statute to other types of obstruction in proceedings, why didn't she just say, on balance, we understand there are First Amendment protections for some protests, and so we chose not to apply it in that way. And we think that January 6th was so egregious that we are now taking that step to apply this statute here. I mean, why go through the pretzel-like manipulation and umbrage that she was falling all over herself? And I thought Justice Alito thoroughly dismantled her.
Yeah, I mean, the attempt to say that, obstruction of an official proceeding would apply here in the January 6th instance, but not to all the other protests of official proceedings that obstructed them. I mean, that argument doesn't work. And I guess I think her view, and probably the view of her team, is that if they don't prevail on this argument, if they don't win, that obstruction of an official proceeding can be cabined effectively to extraordinary extreme conduct, then they're going to lose.
Yeah,
But the problem is,
and we'll have to
gonna
leave
lose
it there. But Will Chamberlain, thanks so much. We're already out of time. We'll be right back with more. Throughout history, there are clear moments that define our nation's path, and now you can own a piece of that history. I'm thrilled to announce the official Newt Gingrich contract with America coin from our friends at Legacy Precious Metals in partnership with Speaker Gingrich. This limited edition 1 ounce 99.99% silver coin commemorates the historic victory in 1994 when the Republican Party, under Speaker Gingrich's guidance, took control of Congress. The Newt Gingrich contract with America coin also symbolizes the transformative political platform that led to the landmark achievements like the overhaul of the U.S. welfare system and the Balanced Budget Act. This is a limited edition coin that will sell out. So whether you're looking for the perfect gift or you want to own a piece of history, act fast before they run out. The Newt Gingrich contract with America coin is more than an investment. It's a tribute to honest government and America. You can order it online at newtgingrichsilvercoin.com. That's newtgingrichsilvercoin.com, and use promo code Jenna, that's JENNA, to get $10 off your purchase. Go to newtgingrichsilvercoin.com now. Well, in the context of the U.S. Supreme Court analyzing whether this statute is overbroad as applied to the January 6th protesters, there were protests that happened all across the country in terms of pro-Palestine over the weekend with the Iran attack against Israel. And why aren't those protesters being construed by the DOJ with, some kind of statute to impose a 20-year prison sentence? Well, joining me now to discuss is our Legal Eagle panel, Mike Donnelly, who is a law professor and attorney, and Ron Coleman, who is an attorney and the host of Coleman Nation podcast, and you're with the Dillon Law Group. So, gentlemen, before we get to the protests of the pro-Palestine, I want to ask you about Justice Thomas, because reports yesterday were that he was absent from the bench, but the Supreme Court and the Chief Justice didn't give any explanation, and then he was just back today, business as usual. Ron, does that indicate anything we should be concerned about?
Not necessarily. I was in front of the Second Circuit yesterday, and hear ye, out come the judges. Well, 2 out of 3 ain't bad. One of them had to go to a funeral. They promised us that she would listen to the transcript, and the Second Circuit doesn't really matter. They not even listening to oral argument, as far as I can tell. But people have private lives, including Supreme Court justices, and there could be a million reasons. Listen, there is no single life that's more important than that of Clarence Thomas. Certainly, in general, and every life is important, and all the things, but he's got to stay healthy. So I understand everyone's concerns, but he was back today, and it's fine federal, evidently. It's life.
Yeah, and I think we can all agree that we want to protect Justice Thomas. May he live forever. So, Mike Donnelly, to Ron's point, though, he was made aware of the reason for the absence of the judge on his panel. Why wouldn't the Supreme Court just indicate if there was something that Justice Thomas needed to attend, or a reason for his absence? But they have at least said that he will take part in the opinion, which probably means that he will read the transcripts or listen to the argument and then participate in the opinion.
Well, Justice Thomas is the longest serving Supreme Court justice, and I agree with Ron. In my opinion, one of the most important thought leaders on the court. He is bringing theories and ideas that our country needs to listen to in terms of returning to a federal republic and reinstituting constitutional jurisprudence. When I heard that he was off the bench for no explanation yesterday, I started praying. I said, we need Justice Thomas to return, and I'm so glad that he was back on the bench today. Look, why did they not make a pronouncement about his reason? I mean, look, why should they? I don't think Justice Thomas needs to explain every time he's not on the bench. None of them should have to either. They are private people, and they should be given some of that privacy. They certainly need protection, though. And, we need to make sure we're protecting them. And I did do, in my research, I noticed that some of the opponents of the court are digging through U.S. Marshal records to try and figure out where the justices are going. And it was interesting to note that Justice Thomas and Justice Roberts, in the last 4 or 5 years, have not been using the Marshal Service, maybe for that reason. And if I were them, that's what I would continue doing. I don't want people tracking my movements either, and I don't think we necessarily have to track every single one of the Supreme Court justices' movements if they're going on vacation somewhere or what have you. Clearly, there's ethical obligations that we need to be aware of, and I believe most of them, if not all of them, are doing that. I mean, I trust Justice Kagan to adhere to her ethical obligations just like Justice Thomas. So that's good call on Justice Roberts and Justice Thomas on maintaining their privacy.
Well, we are grateful that he's back on the bench. And so let's turn to the pro-Palestine protests. And there was a lot of violence yesterday. And so this tweet coming from Colin Rugg on X yesterday, just in, pro-Palestine protesters have stormed the Brooklyn Bridge and are blocking traffic, with one protester reportedly waving a Hezbollah flag. The incident comes after protesters blocked off the Golden Gate Bridge in California and lanes outside the Chicago airport. Earlier in the day, some protesters were heard shouting "Death to America," with one protester burning an American flag in New York City. So, Ron, obviously this is heinous behavior, this is criminal behavior, but it doesn't seem like the DOJ is looking into various statutes to try to construe the highest possible penalty that they possibly could, like they are with the January 6th protesters. So why not?
Well, Well, it makes a lot of sense for them not to be looking for the harshest penalty because they're not arresting people. So you don't have to look for penalties when you're not enforcing the law. Uh, these should not be called pro-Palestine protesters. These are pro-Hamas protesters, but more importantly, what they really are is anti-America protesters. This has gone far beyond any interest in into Gaza, into Israel. The language they're using, the cause they're espousing, is anti so-called colonialism, which means anti. There is no real meaning to the word colonialism here. In fact, the Muslim world, as we know it, is the product of an extremely successful colonial campaign that was undertaken over many centuries. No one's rolling back colonialism. The interest here is in undermining American institutions and capturing and moving the Overton window, so to speak, as to what level of radical left protest and violence and disturbance of American institutions and life will be permitted under the guise of a cause that has a certain amount of public appeal for cultural reasons that we probably don't need to go into right now.
Well said that it should be anti-American protests. So, Mike, your thoughts, and we've got about a little over a minute left.
These are not protests. These are criminal gatherings. They should not be permitted. I did see a few people in the New York case getting some handcuffs put on them, which was the right thing to do. I felt very bad for the folks trying to get to Chicago O'Hare Airport. NYPD, good for them.
FBI,
put some handcuffs on people. NYPD putting some handcuffs on people there. I didn't see the Chicago guys putting handcuffs on those people interrupting O'Hare Airport yesterday. I saw the cars just parked there protecting the protesters, but they're not protesters. They're just getting in the way. The First Amendment, and I love a good protest. I've been to them. I'll shout, I'll hold a sign too, and I'm all good with, blowing whistles and things like that, freedom of speech, freedom of expression, but you can't disrupt your fellow citizens like that. That's not a protest, and that's not what the purpose of freedom of assembly was intended to protect. So stop doing it. Go to City Hall, hold your signs, make your noise. If you want to close down a public thoroughfare, arrange in advance. All the parades, they get permits. You can't do that. It's not a protest. Stop doing it.
Yeah, well, and hopefully America will decide to enforce our laws and have this balance, between what genuinely is First Amendment expression and protected conduct versus what is obviously just criminal activity. But we'll be right back with more with our Legal Eagle panel right after this. Well, friends, you might have heard that Mike Lindell and MyPillow no longer have the support of their box stores or shopping channels the way that they used to. They've been part of this cancel culture, so they want to pass along the savings directly to you by having a $25 extravaganza. I love that word, extravaganza. When Mike started MyPillow, it was just a one-product company. With the help of his dedicated employees, they now have hundreds of products, some you may not even know about. To get the word out, I want to invite my listeners to check out their $25 extravaganza. 2-pack multi-use MyPillows are just $25. MyPillow sandals, also awesome, only $25. Their 6-pack towel sets are $25. And brand new 4-pack dish towels, you guessed it, just $25. For the first time ever, the premium MyPillows with the all-new Giza fabric, just $25. And orders over $75 will receive free shipping too. This amazing offer won't last long. Go to mypillow.com, use the promo code Jenna, or call 800-564-8475 today. That's 800-564-8475, or go to mypillow.com and use the promo code Jenna. Welcome back, and we're continuing the conversation with our Legal Eagle panels, which is Mike Donnelly, who is a law professor and attorney, and Ron Coleman, who is an attorney with the Dillon Law Group and also the host of the Coleman Nation podcast. So, gentlemen, of course, the biggest trial going on right now is the sham, ridiculous trial out of New York state of Donald Trump. And this headline coming from the BBC, because maybe they're a little bit less biased than some of the other mainstream media. We'll get to NPR later in the program, guys. But this headline coming from BBC: Trump trial, dozens of jurors rejected as they say they cannot be impartial. Dozens of potential jurors have been ruled out of Donald Trump's unprecedented criminal trial in New York on impartiality grounds. Mr. Trump denies falsifying business records to conceal a hush money payment to porn star Stormy Daniels just ahead of the 2016 election, which he won. 60 of the 96 potential jurors were quick to say they could not be impartial after proceedings began on Monday. And jury selection continues on Tuesday. So it continued today and could take up to 2 weeks. So, Mike, I'm actually surprised that it would only take 2 weeks. I mean, obviously, Donald Trump is very well known. Everybody has a feeling about him. And so can we get to any sort of impartial and constitutionally sufficient jury in this case?
Well, I hope so. Trial by jury is one of the most important parts of our criminal justice system. I do note that the Trump team did try to move the trial to another place where they thought they could get a better jury. I think it's going to be hard for them to get a impartial jury where they are right now. But even if we can just get one or two people who are willing to be impartial, they might be able to see justice done in this case. And when you think about this case, I wonder if people even realize what we're talking about here. The news, and if you look at Google, it's like NBC, ABC, blah, blah, Politico. You got to really look down to find any neutral analysis. And so I went and I read the indictment again, and they talk about, 34 felony counts. It's the same charge of allegedly falsifying business documents. And it's a felony only because, he's hoping to prove a felony. And to prove a felony of falsifying business documents, you need one, the underlying charge, which is falsifying business documents. And I think there's a question about whether that actually happened. Number two, to get to the felony charge, you have to have intent to defraud plus intent to commit another crime. So the prosecutor's thrown a 34-count indictment here about the same charge. And I think he's got a pretty tough road to hoe. Even if there are jurors there who aren't impartial, I think they're going to have to look at this and say, I don't think this is a felony. If it's even a misdemeanor, probably not. That's my hope. And I think that's what justice requires.
Well, so Ron, assuming that we get to an impaneled jury, that even if there's, a couple that are impartial and they're willing to actually look at this and not just make their determination on either a preferential treatment or hatred of Donald Trump, this seems so convoluted that can the average juror look at this and even make sense of everything that Mike is talking about? Because it seems like this whole entire charge is built on several layers of fiction that really should be tossed in more of a summary judgment kind of mode rather than even proceeding to a jury.
Full disclosure, as you know, both of you know, our firm represents President Trump, not in the criminal proceedings, but in many other respects. I don't believe I would be any less revolted by the nature of these proceedings, regardless. In fact, I'm sure I wouldn't be. It is an absolute shambles, absolute humiliation for the American legal system and that of the state of New York. And you're right, Jenna. This is an indictment that should have been dismissed as a matter of law before any kind of jury selection took place. Can a jury find its way through the case the prosecution wants to make? No, the case is in and of itself irrational, inconsistent. The evidence isn't there for it. And there is going to be the best, in some respects, a conviction, if we had all the time in the world to play it out, would be best, because it would be really what we need is for a reviewing court to throw the whole thing out. But considering the way things are going, an acquittal, I think there's a very good chance of an acquittal. This is not the District of Columbia, a jurisdiction in which jurors would not hesitate and have not hesitated to lie about their bias, and they would already be listening to opening statements today.
Yeah. And so, Mike, in practical terms, if there is a conviction, how does this bear constitutionally, if at all? One, on Trump's ability to run for president in 2024, and second, on his liberty and freedom if there is some kind of jail sentence imposed.
Well, that's a good question. And you know what, Jenna, I don't even want to get to that because I think that that can't happen.
Nice deflection.
That may not happen. Okay, I'm just going to say it. That may not happen if I am allowed to say that. But what I would like to point out is that this just reinforces the two tiers of justice we have in this country and the political aspect of this trial. Why, Hillary Clinton misused her email servers to transmit classified top secret information. Accountability? No. Joe Biden, bribery, corruption, Foreign Corrupt Practices Act. Okay, we have an impeachment proceeding 8, 9 years after, or 6, 7 years after the fact. Accountability? No. So if you're Democrat, one set of rules apply. If you're Donald Trump, Republican, another set of rules apply. That's got to stop.
Yeah, and Ron, to his point, I mean, Will Chamberlain, I was just talking to him on my radio program this morning, and then he was on in the first segment before you guys joined for the panel. And, it's his hypothesis that Republicans need to go as hard after Democrats and make them play by their own rules to reach some sort of, in his terms, settlement to not weaponize law enforcement and the justice system for political opponents. Do you find that persuasive?
I think everyone agrees that since the system itself is, everyone doesn't agree, but since the system itself is not correcting the way it ought to, because the historic trust and stability and shared values that prevented this kind of thing from happening don't work now, that some other way to disincentive this kind of corruption has to be found. And I suppose if there's a way to do it, that would be by having state attorneys general in activist conservative states to start taking similar actions against Democrat politicians. Here's my problem with it, and I don't believe Will Chamberlain would disagree. We should not be encouraging unethical abuse of the legal system in any jurisdiction.
Yeah. And we got to leave it there, but I fully agree. It's never okay to go outside of the margins of the law or the Constitution, even if the Democrats are. But we'll be right back with more. Throughout history, there are clear moments that define our nation's path, and now you can own a piece of that history. I'm thrilled to announce the official Newt Gingrich contract with America coin from our friends at Legacy Precious Metals in partnership with Speaker Gingrich. This limited edition 1 ounce 99.99% silver coin commemorates the historic victory in 1994 when the Republican Party, under Speaker Gingrich's guidance, took control of Congress. The Newt Gingrich contract with America coin also symbolizes the transformative political platform that led to the landmark achievements like the overhaul of the U.S. welfare system and the Balanced Budget Act. This is a limited edition coin that will sell out. So whether you're looking for the perfect gift or you want to own a piece of history, act fast before they run out. The Newt Gingrich contract with America coin is more than an investment. It's a tribute to honest government and America. You can order it online at newtgingrichsilvercoin.com. That's newtgingrichsilvercoin.com and use promo code Jenna, that's JENNA, to get $10 off your purchase. Go to newtgingrichsilvercoin.com now. And joining me now is Matt Tyrmand, who is the head of V-24 Investigations. And your people, Matt, went to Columbia University and caught on tape some of the top professors, including a law professor there, that's actually pushing some of these anti-Israel protests and fomenting anti-Semitism and these comments and rhetoric against Christians and evangelicals. So explain what you found, and then we have one of the videos as well.
Sure. So we did a deep investigation with undercover journalists at the campus at Columbia University, and our operatives had conversations with some very, very senior professors like Rashid Khalidi, who is infamous as the Edward Said Professor of Islamic and Arab Studies. He's a good friend of Barack Obama, who informed Obama's views on the Middle East, as well as in the early 80s, he worked directly in the press office of the Palestinian Liberation Organization. That's Arafat's terrorist organization. So, I mean, these are hardcore radicals. Obviously, as senior people, they come across as a little more dignified. We also have coming, and this hasn't aired yet, but will be airing later today, ahead of the Columbia University presidential congressional testimony tomorrow, much more radical professors. So we'll have, I'm sure, more conversations about that. And I think the clip you're going to show is one of those professors, Mohammed Abdu, who is a visiting professor, lecturer, and he is an incredible radical. And you have some footage of him talking about some of the other stuff.
Let's roll that tape.
There's this amazing professor, I know he's on sabbatical right now, Rashid Khalidi, you're familiar with him, amazing professor, one of the greatest minds, talking about the same things that you're talking about. He was telling me about this anti-Semitism task force that he's seen on campus, and he's telling me that, how the task force is made up of some of the most extreme political people on campus, made up of the most extreme political people they could find.
They pick bigots and fanatics, right-wingers and extremists and people who have attacked students to be on an anti-Semitism task force. It's a scandal, and you can't say anything.
He told me that, they picked bigots and fanatics and right-wingers and extremist people who've attacked students. It's designed to shut down speech on Palestine and specifically any critique of Zionism and critiques of Israel. Is that really what's happening?
He said it. My question is there an Islamophobia task force? Islamophobia is structured when one comes to think about Abu Ghraib, when one comes to think about CVE programs, counter surveillance programs, when it comes to violent extremism discourses, all kinds of different narrations, let alone, again, the very history of this country. So my question is, why isn't there an Islamophobia task force? Why isn't there a task force to examine students of mine that have been subjected to a terrorist chemical weapons attack on Columbia campus? That is the question.
He also told me that he's telling me he's advising students like that not to even communicate on your EDU email.
All of us use a university account.
Right, exactly.
Which, by the way, are not secure.
Really?
They are listening into your personal Gmail account and not university servers.
They're really looking into that?
We don't know, but
yeah, that's true.
I mean, they've instituted a police state, and police states usually surveil. I would imagine that they would be surveilling people in SJP. We know that they found stuff out, maybe through human spies and maybe through other methods.
Because people might be watching, Zionist faculty, whoever might be watching over people's EDU emails.
They are watching.
Too personal. Yeah.
Well, Columbia, I think, generally speaking, is watching, Zionist or not, is watching and is monitoring. So this,
Protests at Columbia University over the crisis in the Middle East.
It's from the river to the sea.
Wow, Matt, this seems like this should be something that Columbia's administration would be concerned about. Have they responded to this at all?
They have not, but again, tomorrow, the Columbia president, Manoush Shafiq, goes before Congress. She had a scheduling conflict a few months ago when Harvard, MIT, and Penn were under the bright lights. So now they're bringing her in. She actually just penned an editorial for the Wall Street Journal today ahead of this, trying to sort of run interference and damage control for herself. But I expect that some of the congressional staff and the committee are looking at these videos, and they will be bringing them up in the hearing. The stuff that Khalidi and Frankie, professor at the law school, that Khalidi refers one of my journalists to. He says she's spearheading, letter writing campaigns and protesting. They're really coercing and pushing students to engage in the protests. She actually says that they've lost all faith in the president because she's too Zionist. This dovetails with what Khalidi says that we just saw, which is they've picked right-wingers, extremists, and bigots to be on the anti-Semitism task force. Let's be honest, to a normal person, to people like us, there are no right-wingers in the Columbia administration. Anybody who doesn't have, their pronouns in their bio is literally Hitler. To these people, if you're not a full-on Hamas supporter that the struggle is real, you are a Zionist. There's no room for middle ground with these people, and I think that is pervasive in the campus. It's what we've seen. Abdu says that the students, the protesting students who are pro-Palestine, are getting attacked in terrorist chemical weapons attacks. there was a student who lit off a stink bomb that you'd get at, the mall for a prank, and he was suspended for it. But this is their framing. This was a terroristic chemical weapons attack. These people are unhinged. This Abdu character, along with some of his peers, some of the younger, more radical professors, we have more videos of them coming out later today and tomorrow. And it just goes down the curve of radicalism to the point of, I think if you're a parent at Columbia and you're paying 80 grand a year, is this what you want your kids seeing? Khalidi's got an academic veneer, but some of these radicals are basically saying from the river to the sea, and let's protest, let's burn it all down, pushing the intersectional playbook and some of the stuff. I mean, they're pushing violent premises and total misinformation. One of the speakers we have on tape is saying that there was no sexual violence on October 7th. That is all propaganda. It's all part of the white supremacy complex that they're pushing this stuff that, the Palestinian movement is a peaceful one. At the same time, it's an armed resistance, but it's peaceful. It's good. We need to be behind it. So there's some pretty damning stuff coming out. Khalidi, in the last part of the Khalidi video, which is on Visegrad24's Twitter account, as well as the new one we launched, V24 Investigates, he's saying, the evangelicals are potentially even more of a threat and a problem than the Jews, because they believe that Israel belongs to the chosen people. They basically believe what the Bible says. And so in places, and he cites Mississippi, Texas, the Midwest, these people are really a worry for us because they really believe it. And then he talks about the rapture and, all the Jews will burn in hell. And then he starts laughing about it. So you get to see his real worldview when he doesn't know he's being undercover filmed. So it's pretty damning stuff.
Yeah, to his students. We only have 20 seconds left, but is there any evidence you've uncovered so far that shows anything about these professors impacting students' grades yet?
No, it's been very, office hours conversations, lectures that have been open to multiple students. So there haven't been any conversations about,
Okay.
you have to write this.
And we got to leave it there, Matt. Thanks so much. We'll be right back with more here on Jenna Ellis Tonight. Well, it's not just radical professors at woke institutions that are trying to discriminate against Christians, conservatives, Trump supporters, evangelicals, and everyone that they want to label as so-called right-wing extremists. It's also now the Bank of America. So this headline coming from the UK Daily Mail, Bank of America accused of religious and political discrimination by debanking or refusing to service Trump supporters, Christian churches, and Republican-led states want answers. Kansas Attorney General Kris Kobach is sending a letter to Bank of America's CEO seeking answers. His letter was co-signed by officials from a dozen Republican-led states. It details how the bank appears to discriminate against Christians. Joining me now is Tho Bishop, who is with the Mises Institute. And Tho, I thought that we've already kind of been through this with, Mike Lindell's cancellation, with other banks and institutions that are trying to cancel conservatives for viewpoint discrimination. Now we have Bank of America.
Right. I mean, this is one of the most powerful tools that the regime has. It's the weaponization of money and banks. And I know Bank of America tried to claim, oh, well, no, this is actually, there's different reasons for doing this. Whenever you recognize a pattern like this, you should always trust your gut recognition of that pattern over the PR gobbledygook that you're getting from these corporations. And the problem is Bank of America has been guilty of this in the past. And again, this is the way that the system is built. A lot of the kind of war on terror, know your lender law sort of stuff that came as part of the Patriot Act, that basically utilized and turned banks into spying tools for the government when they so desire. And so this is not a particularly new dynamic. We've seen greater scrutiny paid to gun owners. We've seen it was used to track people that attended Washington, D.C. on January 6th. We've seen it with other conservative activists. This is not something new. What is new, though, what I think is a very good sign, are state leaders standing up and saying this is wrong and going on the attack.
Yeah, and I think it's incredibly important. I mean, we saw the Mississippi Attorney General or the Missouri Attorney General, rather, who is Andrew Bailey, who's going after Twitter and ultimately Joe Biden and the Biden administration for using social media as an agent of the government. And of course, the First Amendment prohibits that. But where do we fall when we're talking about, some of this this nature of oligarchs that are arising as private actors that are trying to influence the financial sector, like Bank of America, where maybe there isn't a clear, or if any, a trail from a political administration or the government that is forcing them to do this. They're just wanting to cancel Christians, conservatives, Trump supporters, Republicans of their own volition. What should be the response from from not only Americans, but also just from our financial system in terms of providing these sort of protections so that Christians can't just be canceled?
Well, again, unfortunately, the federal dynamic, it's captured. I don't expect any sort of meaningful change to happen in D.C. I do think that this approach, and we've seen it happen in Florida. I know there are some additional protections put in for bank customers in one of the recent legislative cycles here. I think there is a role. First and foremost, again, I do not like big government. I want property rights. I want free exchange. I want free association. The problem is that America right now does not have a property rights environment. We have a civil rights environment. And what that has done is distorted the relationships. It has made murkier this dynamic between state and private discrimination, particularly of these large companies. And so I think there is a role here for states when they recognize that their constituents, that their residents are the ones being targeted by this cartel of federal and corporate power. There is a role there for consumer protections, given that the entire system at the federal level is so rigged against the constituents that are on the political right, that are outside of the preference groups of the powerful liberal elite that control many of these institutions. And I'm glad to see that we're starting to see this tension, this reevocation of federal dynamics here, where states getting more aggressive at trying to confront the consequences of this broken federal system. I think this is we've seen this in a variety of ways. We saw this obviously in a big way with protections over vaccine mandates and the like. I think this is a battlefield where, again, Republicans are increasingly, I think, showing true leadership, again, dealing with the ramifications of the policies decades in the making at the federal level.
Yeah, I think that's so well put, that we're living in a culture of civil rights rather than property rights. And when we look at how nebulous and subject to just complete perversion and arbitrary definitions of what constitutes civil rights rather than property rights, now we get ourselves totally in a mess. But it's also interesting. Conservatives, as you mentioned, though, tend to not like big government and more regulation. But it seems like in this area, we should have some consumer protections, and you shouldn't be allowed to discriminate against a customer just for their particular viewpoint. I mean, any more than the Masterpiece Cake Shop, for example. Yeah, they wouldn't use their own skills and talents to create a custom design cake, but they couldn't just discriminate against any customer who wanted to buy something off the shelf. And everybody sort of understood that proposition. But it seems like that this type of discrimination is only being enforced against conservative owners. But then people like Bank of America, well, they're just free to discriminate against whoever they want on any basis they want. And there's no oversight that is consumer protection. So where do we go from here?
Right, but this is why there's a role, I believe, in, again, going back to the federalist roots that this country was founded upon, with states taking up to resolve or to try to defend their citizens against the consequences of these federal actions. Because, again, banks like Bank of America, their size, their control, their power within this market space is itself inflated by policies that we've talked in the past, policies of the Federal Reserve, policies of banking regulation, right? So when we look at these very, very large, powerful private companies that are willing to do the bidding of the regime, these are not creations of the free market. These are creations, or at least their size, their current place, are creations of the perversion of the economy, the cronyism of the economy, the intervention within the economy. And so if we simply sit back with bumper sticker conservatism and say, golly gosh darn, business can do whatever they want, well, again, that only goes one way. And if the people that support you, if the right in this country are the ones that are being denied these services, they're going to be the ones that are made poor. They're the ones that are going to be made weaker. And the left is going to take advantage of that very real situation that they've created for us.
All right. Well, that just proves why conservatives need to have better solutions, not just, as Tho mentioned, the bumper sticker policies. So that's all the time that we have here on Jenna Ellis Tonight. I'll see you tomorrow.